The next seat that we will move on to is the Geer seat. Many of today's civil cases involve testimony from competing expert witnesses. The North Carolina Supreme Court recently addressed the admissibility of expert testimony in the Howerton case and held trial courts must decide preliminary questions concerning qualifications of experts or the admissibility of expert testimony. The opinion further stated that the trial courts are not bound by the rules of evidence and have wide latitude and discretion when making a determination about the admissibility of expert testimony. The standard of appellate review for trial court decisions on the admissibility of expert evidence is the abuse of discretion standard. As a candidate for the North Carolina appellate courts, what evidence would you generally look for to determine whether the trial court abuses discretion regarding the admissibility of expert testimony? Judge Marty Geer.
Thank you, and isn't that a timely question? Howerton has been around for a bit. It's getting a little age on it, 6 years out, but we really haven't seen much over the past 6 years, but I think we are about to see a flurry of activity. With the SBI lab problem, I think we can safely say that the criminal defense attorneys are going to be litigating the admissibility of expert witness testimony to the hilt. I would urge you as an organization to start monitoring those criminal cases and file appropriate amicus briefs as that issue comes before us. It's coming. And Howerton really sets out three prongs, and we're going to see major battles, I think, on the first two. The first prong in Howerton is the reliability. Howerton said, we are not a Daubert state. First prong is the reliability. Second prong is the qualifications of the expert. Third prong is relevance. There are going to be major wars, and there's going to be development of law on the first two prongs. I noted that the District Attorneys Association filed an amicus brief in Howerton. I don't believe that y'all are going to be aligned with the district attorneys on this one. I suspect we're going to have some strange bedfellows, and the criminal defense attorneys and the insurance defense attorneys are going to have a lot more in common. So I think we need to watch, and I need to be careful, because if reelected, these issues will be coming before us. It's inevitable. And first and foremost, the issue is the standard of review, which Howerton makes quite clear is abuse of discretion. Now I'm going to quibble with the last part of the question, which is what evidence would you look at? Because that's really not what abuse of discretion is all about. The standard of review, I would say one of the most important aspects of being a Court of Appeals judge is understanding your role. And part of that role is understanding how the standard of review works. Abuse of discretion is the test that we use. Was the decision of the trial judge manifestly unreasonable? The issue isn't so much what evidence is out there, but was the rationale, was the reasoning of the trial judge reasonable? One thing I would urge you to do is fight these, you fight these battles extensively in the trial court, but get that laid out in an order. We are most frequently applying abuse of discretion standards in district court cases. We do that all the time. And not infrequently, we have to send those opinions back, those orders back, because the court has not laid out the rationale. Something may look bizarre, but when you find out how the judge reached that decision, you go, oh, no, that makes sense. That's not manifestly unreasonable. That's rational. So I would urge you in your trial practice to make sure these decisions are laid out. Now, I think the standard review gets a little interesting, though, when you start looking at the prongs. Reliability, yeah, abuse of discretion, we don't use the rules of evidence and so forth, and I'll get back to that in a second. The second prong, though, is the qualifications of the expert. And Howerton says that is fundamentally a fact issue to be decided by the trial court. Well, typically, with fact questions, we are looking on the Court of Appeals whether there's competent evidence to support the factual finding. So that's a little different from abuse of discretion. I mean, it still is the trial judge makes the decision. But I think we may see some discussion about how that standard review plays out on the second prong. And what it is there going to be any evidence? I mean, I think the argument can be made, is there going to be any evidence to support the trial court's findings as to the qualifications? The third prong is a little, I don't quite know how that's going to play out, which is the relevance. I don't know that it will matter as much. And that is because that standard, relevance has traditionally been reviewed de novo. But there's no question that Howerton says over and over again, you look, it's abuse of discretion. And the main criticism of Dauber was that, one of the main criticisms was, I think, that the Court of Appeals effectively were being asked to do a de novo standard. What happens on the reliability issue, which is, I think, where a lot of the wars will be, is I think there are no musts in Howerton. It's all shoulds. And so if the trial court lays out a reason for not looking at precedent or disagreeing with precedent, I think it only says should in Howerton. It sets forth the criteria in Pennington and Good, but says that's a non-exclusive list. So I think that any factor that is pertinent to the decisions, required by Howerton is fair game. Thank you for the opportunity to speak with you. I would appreciate your support in November. If you want to know more, my website is judgemarthageer.com, and I'm happy to talk with you during lunch. Thanks.
Thank you, Judge Geer. Dean Poirier.
It's actually pronounced Poirier. It's French, as you might guess. It means one who takes the pears from the tree. I'm currently an appeals referee with the Employment Security Commission. I have two of my former co-workers are here, Daniel Garner and former Chairman Harry Payne. I've been doing that for 13 years. I've heard over 13,000 appeals and rendered as many legal decisions. And I think one of the unique things that I bring to the Court of Appeals is advanced knowledge in administrative law. A lot of people forget that at the Court of Appeals, they don't just hear cases from the Superior Court and the District Court, they also hear appeals from the boards and from the agencies. And if you've looked at some of the decisions made regarding appeals from agencies, there have been some pretty poor decisions. And I think that's from a lack of understanding of administrative law. That's my day job. My night job, I'm a law professor at both the undergraduate and graduate level for 4 different colleges. I've taught over 23 different courses. And if you're going to teach law, you need to learn the subject matter in depth, and you need to stay current in the law. So I bring a certain breadth and depth of legal knowledge to this position. Now, as to our question, as a law professor, I would love to take about an hour, maybe 5 hours to discuss this topic, but I'm not given that. And I won't go through the history of Frye and what some call Dauber, but I as a Frenchman call Daubert, and all the other cases leading up to Howerton. But let's go right to Howerton. Former Dean Ken Brown, who knows more about evidence than I will ever know, has made the remark that Howerton essentially creates a presumption of admissibility of expert testimony. And Professor John Connolly, who knows more about intellectual property than I will ever know, agrees with that. But I think we need to make a distinction as to the nature of the testimony. If the expert is testifying to establish a fact, or if the expert is testifying to describe a principle or a process, I think that's true. But if the expert is testifying to provide an expert opinion, then we're into a more nebulous realm. And as you have probably observed, juries are often give way too much weight to expert testimony. So when we're dealing with expert opinion, in those cases, I think we need the trial judge needs to be much more of a gatekeeper under Rule 702 and under Rule 104A and B. So they need to probe into what is the qualifications of this expert. Is what they're saying consistent with other knowledge in the field? What are the margins of error? They need to do a probative study. In the cases where where it's an expert opinion, if there's not an in-depth search, then there's probably abuse of discretion. In the other cases, if there's too much of an in-depth search, it's probably an abuse of discretion. Because in the cases where you're not dealing with just opinion, Let's face it, members of the jury may know more about the subject matter than you do. I was involved in a case involving farming technology where you could have gone down to the coffee shop and pulled out any 5 farmers, and they would have understood that case better than I did. So in those cases, let it go through to the jury. Let them make the determination of, does this sound right and is it relevant? A reporter recently asked me, what do I have against Judge Geer? Why am I running against Judge Geer? And I'll tell you the answer I told him. I have nothing against Judge Geer. I think Judge Geer is a fine lady. I think she's been a great judge. I understand that she's an expert on appellate procedure. I had another reporter ask me, there's a possibility you'll end up on the same court, because if you win, the Jackson-Hunter race is going to open up another seat, and the governor may reappoint her. And if that happens, how do you feel about that? And I'll tell you what I told him and what I told Judge Geer. I'd be honored. I'm not asking you to vote against her. I'm asking you to vote for me because you think that I bring something unique and valuable to the Court of Appeals. Thank you.